Hi, this is Marc Elias from Democracy Docket, and this is my rundown of what to be watching in court. Last week we saw a big move by the Department of Justice filing its first voter suppression lawsuit of the cycle. What do I mean by that? Normally the Department of Justice is on the side of voters. Its job at the voting rights section is to ensure that federal voting rights are protected. Well, not in the second Trump administration. Nope. They have filed a lawsuit literally to disenfranchise voters in the state of North Carolina. I fear that this is only the first of many to come. So please make sure you're subscribed to Democracy Docket, where you will be kept up to date on all of this litigation. But that is definitely big news from last week and definitely something to stay on top of. So the other really big news of the week was out of the state of Alabama, where there has been ongoing litigation over that state's congressional map. Now, those of you who are regular readers of Democracy Docket know that Alabama drew a map after the 2020 census with one Black opportunity district that was challenged. And ultimately, the court held that there needed to be two Black opportunity districts. That case went all the way to the U.S. Supreme Court and back down. The three-judge panel said, yep, you got to have two. What did the state of Alabama do? Well, they passed the new map with only one. This is just another example of Republican intransigence in the face of an order. Well, this three-judge panel was hearing none of it. They not only said that Alabama did not comply with their court order, they said, you know what, maybe we will throw you back under the pre-clearance regime. What does that mean? Well, those of you who remember the Shelby County versus Holder decision, it used to be that parts of the country that had histories of racial discrimination in voting, before they could make changes to their election laws, they had to either seek permission from a federal court or from the Department of Justice. And that permission, if it wasn't granted, meant they couldn't change their law. And they had to get that before they made the change. Well, that was struck down by the Supreme Court in Shelby County versus Holder, but it wasn't entirely gutted. There is still a provision for federal courts to bail in states if the state has demonstrated a continued reticence to abide by the voting rights of minority voters, or they continue to intentionally discriminate against voting rights, as the judges in this case found. So Alabama definitely doesn't want that to happen. They do not want to be bailed back into preclearance of the voting rights. So they filed something saying, hey, we're willing to not change our map again. We're willing to abide by the two congressional districts that the court drew and just sort of say enough is enough through the end of 2030, but we will see where that goes. But boy, if I were Alabama, I would just stop digging because it's not getting any better. But perhaps the biggest news of the week, the thing that has captured most of the headlines, is Donald Trump once again losing in court another executive order targeting a big law firm. This time, the Washington, D.C. law firm of Wilmer Hale was targeted by one of those clearly illegal, clearly unconstitutional executive orders that Donald Trump has targeted big law firms at. And that got struck down in an opinion written by Judge Leon with 26 exclamation points. That's right, 26 different places the judge used an exclamation point. That is a lot of exclamation points. In fact, it is 26 more exclamation points than is typically found in a judicial order, and by far the most exclamation points I've ever seen in a judicial order. But it gives you some sense of how outraged Judge Leon was at this effort to chill large law firms standing up against Donald Trump. This is now the third in a row of judges doing this. There's one more case we're waiting on involving a law firm, Sussman Godfrey. I am sure that's going to wind up the same way. But the reason why this garnered a lot of attention is because the law firms that capitulated, led by Paul Weiss, big New York law firm, are looking dumber and more cowardly than ever. This is something I wrote about for premium members on Democracy Docket. If you didn't get that, that's because you're not subscribed to Democracy Docket's premium newsletters. The link to become a premium member or to become a free member, if you don't want to take the plunge for money, are above and in the description below. So that's enough with the past. Let's talk about the future. And next week is going to be another big day for democracy in court, kicking off with the U.S. Supreme Court, where on Monday we're going to get further orders from the U.S. Supreme Court, and those can be very important for democracy because the Republicans and their allies have a number of cases they would like the High Court to add to their docket for consideration, and we are tracking them at Democracy Docket. And if there are any new orders in the democracy arena it will be Democracy Docket that will bring that news to you. On Thursday, we will get opinions. So we're getting to that time of year. I mean, it is already June, and this is the month where the big decisions come out of the U.S. Supreme Court, and we are still waiting on one of the biggest democracy cases of the term, a redistricting case out of Louisiana, where a group of white Louisianans are trying to strike down the map that was put in place as a result of a court order to give Black voters a fair opportunity to elect their candidate of choice in 2 congressional districts. We will see what the U.S. Supreme Court does with this, but that'll be a huge case. And I can promise you, when that opinion comes down, you will get notified by Democracy Docket and you will get analysis with what it means in that case and in future cases to come. Okay, so one case in particular I am tracking very, very closely that all of you need to pay attention to. This is a Mississippi ballot receipt deadline case. As you know, the Republican Party is committed to disenfranchising voters who mail in their absentee ballots, but where, because of postal delays, the ballots don't make it to the election office until a day or two after the election. So these are people who cast their ballots before Election Day, but they aren't received until afterwards. There are postmarks that prove when they were mailed. And the Republican Party wants these ballots thrown in the trash, right? They want to disenfranchise all those voters. And they finally got a court to agree with them in a case that the RNC filed in Mississippi against the state of Mississippi. And Mississippi is coming up on the deadline where they have to file what's called a cert petition if they want to challenge us. In other words, they have to ask the Supreme Court, hey, Supreme Court, you should take this case up because we think that the Fifth Circuit in this case got it wrong. So I am watching this like a hawk. It could come as early as this week. Let's wait, let's see. But something tells me, and some local reporting suggests, that the state of Mississippi is going to seek cert in that case. And if so, that is a case to watch. And I think there is a reasonable chance the U.S. Supreme Court actually would take that case. So put that on your calendar to watch for this week and until we finally see it happen either this week or in the future. All right, what else is going on? So the Republicans in Wisconsin are still trying to make it harder to vote and easier to cheat. In the easier to cheat category, they are challenging the fact that Wisconsin is part of an interstate compact known as ERIC, which is basically a way that a bunch of states get together and share voter registration information with each other so that if you move from one state to another state, they remove your voter registration in your old state, you get added in the new state. I know you're sitting here thinking, what's not to like? That's exactly right. ERIC was not originally something that was a project of the left. It was actually something Republicans quite liked because it had this removal feature, prevented duplicate registrations and the like, which Republicans claim they care about. Well, Republicans decided in advance of the 2024 election that they'd rather believe in wild-eyed conspiracy theories than actually have clean voter rules. So a whole bunch of Republican states left ERIC, and the Republican Party in Wisconsin decided to sue to try to get the Wisconsin state out of ERIC. A hearing is set in that case on Monday. Let me tell you, this case isn't going anywhere. The Wisconsin courts are not going to require Wisconsin to get out of ERIC, but it's an important case to watch because it shows that Republicans are still on this conspiracy theory. They are still trying to set things up for challenges in 2026 and 2028. And Democracy Docket will cover it because it's always interesting to see what arguments Republicans make, particularly after we've had an election in Wisconsin that I assume Donald Trump was pretty happy with the outcome of. All right, on Friday, there is a preliminary injunction hearing in a lawsuit filed by 19 states against a Donald Trump executive order that tries to impose documentary proof of citizenship and also that ballot receipt deadline. It tries to do this by executive order. He cannot do this by executive order. The Constitution doesn't give the president any authority here. The authority rests with the states. And if Congress passes a law with Congress has not passed a law here. Instead, Donald Trump is trying to exercise unilateral power that he does not have. That is not just my opinion. That is what a federal judge in Washington, D.C. said with respect to the documentary proof of citizenship claim that was already litigated on behalf of the Democratic Party. I know because my law firm and I litigated that case and we won. So I'm good. It's good to see the states bringing similar claims, and I assume we'll get the same results. Look, that's it for next week, but I got one final thing. I said at the top that this lawsuit by the Department of Justice in North Carolina is a watershed moment. This is the Department of Justice using your taxpayers to try to make it harder to vote and actually to try to throw out ballots by people who are otherwise eligible to vote and have done nothing wrong. Look, let me make this clear. Whatever you may have thought about Merrick Garland and whether he did enough, he was always on the good guy side. Maybe not as often as you would have liked, but he was always on the right side. With Donald Trump's Department of Justice under sycophant Pam Bondi, a certified election denier, now bringing cases to make voting harder, we're going to have to see more private actors intervening in these cases to fight them. And something tells me that as early as next week, we may start to see just that in this North Carolina case. When that happens, if that happens, make sure you are subscribed to Democracy Docket because they will have that news and they will give you the context and the information necessary. So please make sure you're subscribed. And one last thing, go ahead and if you're not already subscribed to this YouTube channel, hit the subscribe button. Also hit the bell to make sure you get alerts every time there is news videos like this one and like the breaking news videos that Paige and I regularly do. It is a really vital way to keep you informed. I'll see you next time.